Hello, everybody. Good evening. My name is Margaret Heldring, and I am the founder of Grandmothers Against Gun Violence. And along with our partners, the Museum of History and Industry, MOHI, to us in Seattle, and the Alliance for Gun Responsibility, we welcome you and we appreciate your presence here this evening. We will introduce our moderator and panelists in just a moment, but we want to start with a thank you to Naomi Ishisaka from the Seattle Times, Professor Charlotte Whitmore from Boston College Innocence Program, and Executive Director Laura Zarowski from Washington State's Innocence Project. We will move through the program and then welcome your questions that you will properly put in the Q&A box, and we will attend to those happily at the end of our presentations. This is Grandmothers and our joint fourth annual Grand Conversation. And occasionally the question comes up, what do you mean by a grand conversation? And the answer is, it is one imagined and led by an older generation on the premise that we're well positioned to model listening, bringing together people with different points of view and different lived experience around guns and gun violence, and to help lead the search for common ground and for solutions to this painful epidemic. MOHI, the Alliance, and Grandmothers are all committed to community outreach and engagement and to racial justice. We want to showcase groups and organizations that have as their mission something that is good, that is right, and that is needed. And that is the Innocent Program and Innocent Projects you are going to hear about this evening. As the Washington State Innocence Project notes on its website, innocent people are often convicted of crimes they did not commit. And it comes as no surprise that the impact of this is greater on Black people, Indigenous people, and people of color. And that these experiences are traumatic and unjust. I hope as you listen this evening to the stories of the Innocent Project and programs, you will experience the sense that these are something of an oasis of justice and hope in this time. So we are really excited to introduce you to this movement, to this work. And now it is my pleasure to turn it over to Anthony Long from MOHI, who will get our presentation underway. Thank you all again.
Good evening. My name is Anthony Long, and I am the Executive Associate and Board Relations Manager at the Museum of History and Industry. Before we begin the program tonight, I want to acknowledge that here at MOHI, we are on the historic and contemporary lands and waters of the Duwamish, Suquamish, Muckleshoot, and all Coast Salish people. Historically, Native communities were forcibly removed from this city. Today, we honor their continued endurance with deep respect and gratitude for their unbroken stewardship of this place. We also encourage you to visit the website of local tribes to learn more about the people whose land you are on. Here at MOHI, we are honored to partner with the Grandmothers Against Gun Violence and the Alliance for Gun Responsibility to facilitate the fourth Grand Conversation, Justice in Our Time of Gun Violence, exploring the work of the Innocent Project. One of the museum's core strategic goals is to be a catalyst for learning, a catalyst for community, and a catalyst for conversation. We are proud to work hand in hand as partners with the Grandmothers and the Alliance in facilitating this conversation on such a critical issue in our time. I would like to thank Grandmothers Against Gun Violence and the Alliance for Gun Responsibility for the activism in addressing gun violence in our communities, and our wonderful panel for taking the time to lead tonight's conversation. Without further ado, I would like to introduce to you our wonderful moderator, Naomi Ishisaka. Naomi is the Assistant Managing Editor for Diversity and Inclusion and the Social Justice columnist for the Seattle Times. She is an award-winning journalist and photographer who focuses on racial equity and social justice.
Thanks so much, Anthony. It's great to be here with all of you, and thanks to Margaret and Grandmothers for organizing this event. I've had the privilege of doing this several times before, and it's always such a rich conversation, and I always learn a lot. So thank you for putting this all together. First, just want to get started with the introductions of our panelists today. First, want to introduce Laura Zarowski, who's the Executive and Policy Director of the Washington Innocence Project. Following her work as a nonpartisan counsel in the Washington State Legislature, Laura joined Washington Innocence Project in 2010 to lead its policy efforts. In 2011, Laura joined the faculty of the University of Washington School of Law to establish the Washington Innocence Project track of the Legislative Advocacy Clinic, which she directed from 2014 to 2019. Her clinic students championed a 2013 law to compensate Washington's wrongly convicted, a 2015 law to preserve biological evidence collected from crime scenes, and a 2019 law to establish and implement best practices for gathering and use of eyewitness and incentivized witness evidence. In 2021, Laura led the successful legislative effort to mandate the recording of all custodial interrogations in Washington State. Laura was recently elected to her second term on the National Innocence Network Executive Board, where she serves on several committees and working groups. She received her undergraduate degree from the Evergreen State College, my alma mater, and is a graduate of the University of Washington School of Law, alumna of the Washington Innocence Project Clinic, and holds a certificate in nonprofit management through the University of Washington. Thanks, Laura, for being here. And Charlotte Whitmore has been the senior staff attorney at the Boston College Innocence Program since 2013, and began also working as a legal director of an exonerated-led nonprofit called Life After Justice in January 2023. Charlotte was previously employed by the Middlesex District Attorney's Office to focus on innocence and conviction integrity matters. And prior to that, she was the first staff attorney at the Pennsylvania Innocence Project. Charlotte earned her undergraduate degree at Dartmouth College and graduate degrees in both law and education from the University of Pennsylvania. Charlotte formerly served as a law clerk for Honorable Marjorie O'Rendell of the U.S. Court of Appeals for the Third Circuit and U.S. District Court Judge Anita B. Brody. Welcome to both Laura and Charlotte. Thank you so much. Just to give the audience a little preview of what we're planning, we're going to have some opening remarks from the panelists, go into Q&A, and then a discussion, and then at the end we'll do audience Q&A. So you should see a Q&A button at the bottom of your screen. As Margaret mentioned, please put your questions in there. We really want to have this as interactive, engaging as possible, and want to know what questions you have. So don't hesitate to put them in there, and we'll get to them when we get to the end of the program. So we want to get started with Laura giving some opening remarks. We'd love to hear from you a little bit about the work you do and what you want to tell our audience.
Great. Thank you so much, Naomi. And I just want to thank the Mohai and the Grandmothers for the invitation to be here. It's really a great forum, and I'm really excited to participate. So thank you so much. As you know, I represent the Washington Innocence Project, and I think it's sort of, if you aren't really steeped in this work, this isn't something that's really commonly understood. But those of us who do work in the innocence movement, you'll hear the name Innocence Project, and there is an organization called the Innocence Project. They're based out of New York City, and they are the largest and first innocence project that was established in the country. We were actually the second. We were number 2 under the name Innocence Project Northwest in 1997. We were founded by Professor Jackie McMurtry at the University of Washington School of Law. And we really thought we could handle the whole Northwest region because DNA was there and we were going to get all the innocent people out of prison and close our doors. And as it turned out, the problem was much bigger and broader and deeper than any of us realized at the time in 1997. But it's really important, just as a framing, to understand innocence projects. If you have that name, like we both do, well, we do, if you have the name Innocence Project, it doesn't mean that you're a part of the Innocence Project in New York. What it means is that we are affiliated through the Innocence Network, and we have qualified by our organizational structure and our ethical structures and our sort of the guidelines that we do our work by to be affiliated in the Innocence Network. And so that is its own it's its own thing. So each individual Innocence Project is individually run and funded. So if you want to support the work, the great work that's happening in Boston, you support the Boston Innocence organization. And if you want to support Washington work, it's the Washington Innocence Project. So there's plenty more to be said there, but I'll just give you that in terms of background. The first known exoneration of, the first exoneration based on DNA was in 1989. So a lot of the numbers that you'll hear me talk about are couched from that timestamp, and that's simply because that was the first year that DNA was used to exonerate an innocent person. But many, many, many exonerations, most of them are not DNA exonerations. They can be all different kinds of new evidence or different evidence that came in and was able to be introduced to question the safety, as the British call it, of that conviction. And so that's a really important factor to understand in our work. We have 20 freed and exonerated clients. 16 of them are fully exonerated from all over the state of Washington. And if you take a step back and look nationally at the known cases of wrongful conviction nationally that have been documented just since 1989, there are now 3,399 of those cases. There's a really incredible resource called the National Registry of Exonerations, where you can go, that they regularly update that resource, and you can search by the race of the defendant, the county where the crime was convicted, just by state, by cause or contributing factor to wrongful conviction. So it's a really incredible resource that is also itself an independent foundation that needs funding. So all of this work happens through the good grace of those who donate to this work and see that it's important beyond what the government does in this space. I think it's really important to note too, though, that the way that this work, we all share information. We do amicus briefs from the Innocence Network on behalf of cases in which an issue that's relevant to actual innocence, a case, a factor that's been known to be a contributing factor to wrongful conviction. We're doing a lot as a network to kind of work together to try to understand those issues better, to track the science as it develops, the research as it develops in areas such as mistaken eyewitness identification, or false testimony by an incentivized witness, or false confessions. There are all of these areas that we know to be the major contributing factors to wrongful conviction. So as I was thinking about the audience here and the interest that all of you have that brings us together around gun safety and the tragedy of gun violence, I was really thinking about how there are some parallels between that work that is very difficult work and the work that we do, which is really, by some estimates, just impossible. There are a lot of cases of wrongful conviction that there's no way to get in there. And so in some ways, I think the problems feel a little bit similar in the sense that they're really daunting and seem really difficult to take on. But there are some really important consistencies, I think, in how we need to approach this. The root causes matter. The reason for wrongful convictions matter, and they're not a mystery. The root causes of gun violence are, if not completely understood, at least there are factors that we understand about those things. And there was a book that was written almost 100 years ago called Convicting the Innocent by a Yale law professor named Edwin Borchard. It's a great book. You can get it in reprint since 2010. And it outlines 65 known cases of wrongful conviction from the United States. And all of the factors that you see in those cases from almost 100 years ago are the same ones that we know now to be a problem. We know that eyewitnesses are unreliable, not because they're bad people or they're ill-intentioned, but because eyewitness memory is not reliable. We know that people who are given incentives in their own case will lie and lead to the conviction of an innocent person. We know that there are political motivations that lead to prosecutions. We know that that people falsely confess, even though that seems crazy, and that we believe we could never imagine actually admitting to something that we didn't do. We know that it happens over and over and over again. Over a quarter of DNA exonerations were a case in which someone pled guilty, in which someone falsely confessed. We also know that there are a lot of reasons to plead guilty in the system, and guilt is only one of them. At least 10% of DNA exonerations are cases in which that person pled guilty. And so this is, I think, the place in this discussion around wrongful convictions, the contributing factors to wrongful conviction, that there really is an interesting crossover in terms of discussion. before becoming the executive director, I was our policy director for 10 years. So going into the policymaking space and trying to think about solutions to difficult, that sometimes feel like insurmountable problems, was really, what my whole job was. And one of the very difficult parts about doing policy reform work around actual innocence is that our system says on paper that it works in a particular way. There's a presumption of innocence. Only this kind of evidence can be brought in. Only reliable testimony will be put on the stand. And so all of these presumptions operate in such a way that makes it really difficult to identify, like, what do you do differently? If the system says on paper that it works this way, what do we do when it doesn't, when it doesn't work that way? And we end up with the exact opposite of what we want, which is an innocent person being convicted, which also means that the actual perpetrator escaped justice. So what do we do in that scenario? And I think that there is a real temptation to do things like increase sentences. If we hate something, if we abhor conduct, we want to say we're going to send a message by increasing the consequences for that behavior. And to some extent, and in some places in the criminal law, that may be effective, and in others it may not. One of those areas that this whole discussion reminds me of is the discussion around capital punishment. And I will reveal that I'm also on the board of the Washington Coalition to abolish the death penalty, so my position on that would be pretty clear. But whether you support or oppose the death penalty, one of the things that's really clear from the research is that the death penalty is not a deterrent to murder. It does not deter murder. States where there is a death penalty, there is not a correlation between a lower homicide rate and the presence of the death penalty on the record. And I think when it comes to the question of gun violence and how do we address this, what do we do as a policy matter? How can we approach this problem? A very natural solution to that, I think, has been, well, let's increase the penalties. So we have something called gun enhancements in Washington state, that if you have certain felonies, if a gun is involved, there's an enhancement of an additional 5 years for each charge. And that may operate in some ways to accomplish the goal, which is to, of course, to reduce gun violence. However, when it comes to wrongful convictions and we think about all the different reasons that people plead guilty, a gun enhancement is an arrow in the quiver of prosecutors that will impact a person's decision about whether or not to plead guilty. And that decision to plead guilty, again, as I just referenced, really has something to do with guilt or innocence, but a lot of times it doesn't. And we know that actually innocent people plead guilty because the stakes of going to trial are simply too high. If they are convicted, then, if they've got a gun enhancement, if they didn't do it, but there's a gun enhancement being held over their head and there's other kinds of evidence, that could operate to actually encourage more actually innocent people to plead guilty to avoid those harsh punishments. So this is an issue that really I started thinking about as I was asked to, join into this conversation. And I think it's just an important piece to gently suggest that some thought be given to the impact on the actually innocent when it comes to the pressures that are experienced in terms of pleading guilty. And, we can ask, well, 10% of DNA exonerations, that's something, but how many people are we really talking about? And I think the primary difficulty of trying to do reform in this space, in the actual innocence space, is that there are very few. Each of these organizations that are around the country, there are 72 Innocence Network member organizations, but none of us are very big. And there are not nearly enough resources in each state to actually respond to the requests for assistance that we get. We get 300 to 500 requests for assistance every year. And not everyone's from Washington, but a lot of them are. And so how do we really evaluate how big the problem really is? And so I'd submit that without really going back and doing a wholesale reevaluation of every criminal conviction that's out there to see whether it was a case of innocence or not, we really don't know what our error rate is. And so as we look at policy solutions to problems that we all agree absolutely have to be solved, we want to be looking towards policy solutions that we know are going to have an impact on the actual contributing factor, the causes of that issue that we're trying to address, and not have collateral consequences for actually innocent people. So I think that's my time for now. So I will turn it over and look forward to any questions that people might have. So thank you.
Thanks so much, Laura. Now, Charlotte, if you could do an opening as well?
Absolutely. Thank you. Thank you, Naomi and Mohai and grandmothers for having me here. I'm excited to be, I think, the sole East Coast representative on this panel. So I'll start by just giving you a little bit of background about the organizations I work for, and then I'm going to tell a story about one of my clients. So I currently work at BC Law School. I teach a clinical legal education program. So we are working with law students to investigate and litigate cases of people who are wrongfully convicted. We have 10 second and third year law students who work with us throughout the entire school year. They work about 25 hours a week just on our cases. We teach them how to practice this type of law, how to write briefs, how to do oral arguments, how to do the investigation that can eventually lead to an exonerating an innocent individual. At the BC Innocence Program, we have freed or exonerated 7 clients since 2019. We're a relatively new program. And simultaneously, I'm also working for a brand new nonprofit organization called Life After Justice, which is a standalone nonprofit that was founded by exonerees and is led by a board of exonerees. And it has a 3-pronged mission. The first is to represent people who've been wrongfully convicted of crimes, which is very similar to the work I do at the BC Innocence Program. But Life After Justice also is doing research on the primary causes of wrongful conviction to try to make changes in the criminal justice system. And they are assisting with the reentry needs of exonerees. So one of the major problems that we face, or challenges that we face in the work that we do, is once our clients are released after often having spent decades behind bars for a crime they did not commit, there are very few resources to help them re-enter into society. They need IDs, they need jobs, they need health insurance. So Life After Justice has decided to focus on providing mental health support to exonerees as they re-enter into society out of incarceration. When I was talking to Margaret about how to frame this talk, one of the things that really stood out to me as the overlap between gun safety and the innocence work that we do is thinking about the victims. So in most of our cases, not all of our cases, but in most of our cases, there are victims of crimes. And we think about those victims a lot, and we think about the tragedy that occurred and the impact that it had on their families and the ramifications throughout their community. But in wrongful convictions, there's another set of victims, because you have the exonerees, the person who is wrongfully convicted of a crime, who's a victim, and that person's friends and family in their community who's also impacted by the fact that there was a wrongful conviction. And I thought I'd share a story of one of my clients. He's out of Philadelphia when I was working at the Pennsylvania Innocence Project, who was wrongfully convicted of a fatal shooting. He was only 16 years old when a store owner in his neighborhood was shot in the middle of the night. My client's name was Eugene Gilliard. The only witness to this shooting was the store owner's daughter, who had awakened in the middle of the night around 2 a.m. to take her young son to the bathroom. She heard gunshots. She looked out the window of her second-story apartment building, and she saw her father being shot on the streets of Philadelphia by 2 perpetrators. She saw the perpetrators for 5 to 10 seconds. She was looking through the blades of a window fan that was installed in her apartment that had been turned off. And she was with her very young son when this occurred. The police investigated the crime, and at the time they believed she was the only eyewitness. She was unable to give a detailed description of the perpetrators, and she was unable to make an identification. This was in 1995. About 4 years later, a cold case squad in Philadelphia reopened the investigation, and they brought some photo arrays to the victim's daughter's home. And she identified my client and his co-defendant from those photo arrays 4 years after the crime, stating that she wasn't sure, but she thought it was them. Based on this evidence alone, my client and his co-defendant were convicted of murder and sentenced to life in prison without the possibility of parole. They were about 21 years old at that time, and they were sentenced to die in prison. About a decade after their conviction, we began working on their case at the Pennsylvania Innocence Project, and we reinvestigated the case. And we learned that, as is common in this type of shooting, that many people in that neighborhood were present for the shooting and knew exactly who did it, and knew them by name, but the culture was to not speak up and to not cooperate with the police. And so no one had told the police the truth. So we quickly learned who most likely the true perpetrators of this crime were. And we went to speak to one of them, who was incarcerated himself. And after he committed this crime, this murder, he had committed numerous other murders and robberies, all using firearms. He was in prison for he was serving 2 separate life sentences for 2 other murders at this time, and he decided to tell us the truth. And he told us that he, in fact, was the perpetrator of this crime, and gave us significant details about how he did it and why he did it, when he did it. But that wouldn't be sufficient to exonerate our client. You'd think a detailed confession from the true perpetrator would be enough, but we knew we had to corroborate that confession, because judges or prosecutors often think that people fabricate confessions to help out somebody, even though there was no connection between my client and the true perpetrator. So what he told us, the true perpetrator, was that he shot another man with that same firearm the same exact day of the murder. And we found that man, and he confirmed that he was shot by that person that same day. And then we found his hospital records confirming that he was shot the exact same day of the murder in 1995. And after we had this evidence and we put this forth in our petition, 3 other eyewitnesses came forward and testified that my client was innocent and that these other perpetrators were in fact the true perpetrators. One of those eyewitnesses was my client's co-defendant's brother, who tearfully testified on the stand that it was in fact his other brother who committed this crime, and he had been living with this guilt for 10 years, knowing that one of his brothers was wrongfully convicted of a crime that his other brother actually committed. He had been, it had been eating at his conscience to live with that guilt for 10 years. So you can see just from this brief story how many different victims were affected by this wrongful conviction. We had the original crime victim, his daughter, his family, the multiple other victims that this real perpetrator committed crimes against in the years when he wasn't apprehended for this crime. And then of course my client and his co-defendant, who as young men were wrongfully convicted of a crime they did not commit and sentenced to die in prison. In this particular case, I spent a lot of time with the victim's daughter, the eyewitness to the crime, who had identified my client and his co-defendant, and empathized with her and tried to show her that I understood the trauma to some extent that she had been through, and that I wasn't not attempting to re-traumatize her, or, as Laura pointed out, she didn't do anything wrong. She genuinely believed that she had identified the right person. And she actually asked the DA's office in this case to reinvestigate the case. And they ignored her and fought us in litigation for over 2 years to try to prevent us from succeeding in our exoneration. But fortunately, the judge heard all of the evidence and vacated the convictions of my client and his co-defendant after multiple years of litigation, and after they had spent over 15 years in prison for a murder they didn't commit. Thank you.
Thanks, both of you. I guess, to follow up on that story, Charlotte, I really appreciated you sharing that. I wondered if you could go into a little bit more detail about, I think there's sort of a perception, in the imagination that once you're exonerated, that's like the end. You walk, the movie ends, the credits roll, like everything's great, you move on with your life. It's like you're saved, your victory. And I guess I'm wondering if you could talk a little bit about the sort of the long tail of being wrongfully convicted and what that actually looks like in terms of, your ability to, re-enter society and some of the casualties of that, especially, for folks with families and other folks who have been impacted.
Absolutely. I mean, Laura and I struggle with this, I'm sure, with many, many of our clients. They're all in very different positions. So some clients are released from prison and they have very supportive families and they have established families. And of course, they have the trauma of the wrongful conviction and the injustice of all the time that they spent incarcerated. But as far as on a spectrum of reentry, we have some clients that have a relatively, it's not easy, but have the support that they need to reenter into society. And the story I just told Eugene, for example, he was released in 2013, and he just texted me that he has earned his associate's degree, and he has a wife and 3 children now, and he recently purchased his own home and has been employed essentially almost since the day that he was released. He had a ton of family support and he had a lot of help along the way. He also had a lot of drive, and he managed to keep positive in the face of a lot of really, really difficult situations that he had been in over in the course of his life. But then we also have clients who have lost everyone they know and love. I had a client who was incarcerated for almost 3 decades, and he lost both of his parents, his siblings. He had no one, he had nowhere to live when he got out. So the challenges really run the gamut, and reentry support is crucial to our work. At BC, we're really fortunate. We have an interdisciplinary program where we partner directly with the School of Social Work. So students who are earning a master's in social work partner with our clinic, and they help draft reentry plans and assist our clients in many of the needs that they have when they are reentered. But it's an extreme challenge.
Laura, did you want to add anything to that?
Yeah, I think the way that Charlotte described it is really spot on. It really varies case by case, but I think that there's this sort of widespread misconception that everybody who's actually innocent, walks out of prison and there's millions of dollars bestowed upon them and then everything is fine. And the truth is, most people who are wrongly convicted aren't entitled to any compensation at all. And so if you live in a state where there's not a wrongful conviction compensation law, then the only avenue available to you is a federal lawsuit where you have to prove deliberate misconduct on the part of law enforcement and prosecutors. And sometimes that's present. And very often it's just a series of, no one did anything wrong. It was just the outcome was wrong. The testimony, people, believed what they saw and they were wrong. These things just happen. And so even the first law that we passed was the wrongful conviction compensation law in Washington State. My students and I got that passed in 2013. And the idea was, hey, you're worse off being actually innocent of a crime and reentering than if you had committed your crime, because you don't have access to even the minimal reentry services that are available through the Department of Corrections. And so we tried to address that in some way by having this wrongful conviction compensation law, which is a civil proceeding. The problem is that the Attorney General's office, who represents the state in those cases, even in DNA exoneration cases, fights everyone. So they end up with, after working to exonerate themselves in the criminal system, then they're in the civil system that's meant to be an easier path forward. But we've seen nothing but absolute utter resistance from the state in those cases. And so it really is just one fight after another. And so if you fall into one of those categories, then very often there's a couple of year period, even if you're compensated, where if you have addiction issues or you developed addiction issues because of the trauma that you experienced, or you fall into old patterns, or maybe you're reincarcerated, there are all different kinds of things that can happen, and it's understandable why. And I think this would be a good moment to identify sort of a growing trend from our perspective. And I think it's alarming on a fundamental justice perspective, but there's a growing trend to prosecutors offering what's called an Alford plea. So Charlotte, I'd be interested to know if you see this more, but when a client has a really strong case of innocence, the way that it works is that the conviction can be overturned. That's all that can happen. And then it's up to the prosecutor about whether or not they're going to re-prosecute that person for that same crime or not, because if the conviction's overturned, then legally it's as if it didn't happen. So now double jeopardy doesn't attach because that conviction is vacated. So now, is the prosecutor going to try to re-prosecute even though the conviction was overturned? And so many, many, many people, because the system already failed them, do not want to roll the dice again and will agree to take what's called an Alford plea. So they plead guilty to usually a lesser offense, while maintaining their innocence. So it's a way of saying, I acknowledge that I could be convicted. Of course, they have to acknowledge that because they were already wrongly convicted. And I'm going to take this deal just so that I don't, to put it to bed. If you do that, though, you're a convicted felon. You can't seek compensation. You are not exonerated. And so this is sort of on a justice level, a lose-lose. On the prosecutor's level, probably a win-win. They get to still say they have a conviction and that person can't go get resources and try to sue the state or get compensation. But for the wrongly convicted person, they sort of, it's almost like having to take a false confession, pleading guilty to something that you didn't do, just to make sure that you can get your freedom. And so it really is a catch-22, and an enormous number of wrongly convicted people, even if they're acknowledged as exonerated, don't get compensated.
It's great that you all said that. That was actually one of the audience questions that have already come in. So you've already answered it. So way to go. I did want to ask you if there are some, I guess, pre-existing qualities or demographics that are more at risk for being wrongly exonerated or wrongly convicted, and if there's anything in terms of race or income or any other sort of indicator that would lend to a higher rate of wrongful conviction. And either one of you, if you want to.
Yeah, I'll just jump in quickly to give a shout out to the National Registry of Exonerations that I mentioned, but because they're so data heavy, that's what they do, is they manage the data around wrongful convictions. They have published white papers on this exact topic, related race and wrongful conviction, and it really parses the data in a million different ways and really helpful and illuminating ways. But some highlights are that you're 7 times more likely to be wrongly convicted of murder if you're a Black man than if you're a white man. Just for instance, just 7 times more likely. Any community that's over-policed, that are lower income, all of those communities and communities of color, all of the statistics over and over again will demonstrate repeatedly that Black and brown people are far more likely to be wrongly convicted. And so that is absolutely a reality, and the statistics really bear it out.
Yeah, I was gonna mention that study as well, but in addition, one of the primary causes of wrongful conviction that Lara talked about earlier was false confessions. And there's been a lot of research done on characteristics that can make people more susceptible to falsely confess. Juveniles are more likely to falsely confess. People with intellectual disabilities are more likely to falsely confess. And so there are certainly characteristics like that can make somebody much more vulnerable to police interrogation and to coercion, and to make incriminating statements that aren't true.
Mm-hmm. And I guess sort of to follow on that a little bit, I was struck by what you said, and I'll go back to that in a minute, but struck by what you said about the sort of smallish nature of these projects and lack of resources. And I was wondering if you could expand on that a little bit and talk a little bit about what some of the barriers might be to having more sort of public interest and support and policymaker support for this kind of work, and what some of the barriers might be that might be limiting that.
Yeah, that's a great question. I think the reason, first of all, I do get this question as like more from the Innocence Network Executive Board perspective. Why is it that this is so fractured? Why are there so many different projects, right? And there are 72 different projects worldwide, but there kind of has to be, because each criminal justice system is different state by state. So the procedures that you use, the way that prosecutions happen, the way that convictions can be overturned, whether compensation, it's all state by state. So we don't really have a criminal justice system. We have many, 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 many criminal justice systems, plural. And so it really would be impossible. This is one of the reasons that, the Innocence Project in New York is the first one. They do take some cases around the country, or they had historically, but there's really no way to do a national model in this way, which is why the Innocence Network is so important, because we're able to come together, support each other, share information and research, and kind of find a way to maximize the efficiency of moving these issues forward in sort of a more cohesive way. There is a tremendous, I don't know if there's a way to say a stronger word than tremendous, amount of resistance from the powers that be, from local prosecutors and law enforcement, to preserve convictions. And it is in the letter of this every statute out there that governs, ethical rules and statutes governing prosecutors that say it is their job to seek justice and not convictions. But we have a case in Benton County where our client, it was a single perpetrator sexual assault case, and all of the evidence does not implicate our client and implicates one very particular person. And even in that case, the prosecutor is defending their own conviction, saying that our guy still is the one who did it, with kind of a crazy theory to explain it away. There's so much inertia to prevent this moving forward. And I think it's got a lot to do with, it's got a lot to do with just human psychology. There are biases in those positions. We all, there's a really strong culture within law enforcement and prosecutors' offices to stand by their convictions. There's sort of this misplaced sense that they somehow have this ability to decipher good people from bad people, quote unquote, that they kind of, if you ever hear someone talking about their gut when it comes to a conviction or whether someone's guilty, please run the other way and don't trust that person's judgment. They are not a critical thinker. This is not how we can be moving forward in a way that's going to protect actually innocent people and identify actual perpetrators. We can't go by our gut. And just to kind of the earlier point around, the fact that Black and brown people are more likely to be wrongly convicted is not an accident. There is a tremendous amount of bias that doesn't make people bad. It makes them people. There is a bias that goes along with how you do your job, the things that you regularly see, and making a lot of presumptions and mental leaps. And those mental leaps, maybe they get convictions, but they don't necessarily get convictions of actual perpetrators. And so that is where we really need to be challenging the broad discretion of prosecutors and law enforcement to do their jobs in the way that they do without any objective checks. When a prosecutor, and to my earlier point, which I'm not sure I made very clearly around gun enhancements, when a person with a gun commits a crime, they can be offered a plea pre-trial. They could be offered a plea for 6 years. We'll give you 6 years if you just plead guilty. But if that person goes to trial, they face 20 years plus gun enhancements. They're looking at 30 or 40 years. And then at sentencing, even though they would have offered 6 years pre-trial, at sentencing, that prosecutor is saying, this is a horrible person who's a danger to our society, and they have to have 20 years, 25, 30 years in prison. Well, I'm not sure what changed other than the trial between the plea bargaining process and the trial result. It's what we refer to as the trial penalty. And this is why people plead guilty. And so the more sort of charge stacking that the prosecutors have discretion to do, the more, the more tools they have to use in that process, the more likely it is that people are going to plead guilty to avoid that. And then we end up with wrongful convictions that are not the traditional wrongful conviction, but they are, an innocent person pleading guilty, which results in the conviction of an innocent person.
The only thing I'll add to that was all very well said. In terms of, you asked the question about the resources, and why our projects are under-resourced. Some of the reason, obviously funding is a huge issue, but also it's very, very, very hard to litigate a post-conviction innocence case, and it takes years. So I think I read a study that like the average time from an Innocence Project, receiving that first letter in the mail where the inmate says, hey, I've been wrongfully convicted, can you look into my case, to the actual exoneration, like the dismissal of the charges after they've been vacated, is something around 7 years. It's really, really long. And that's because, to Laura's earlier point, most exonerations, of the over 3,000 exonerations on the National Registry, 375 of those are DNA exonerations. So all the rest of them are non-DNA exonerations, and those cases involve extensive reinvestigation. We don't have police officers like the prosecutors do who can do that investigation. We have to do that all ourselves. At BC, I do it with students. We go in and out of prisons, we interview witnesses on the street, and you need such an extraordinary amount of new evidence to prove innocence in a non-DNA case. You can't get one new eyewitness, one expert, one little tidbit of information that doesn't quite line up with who the prosecutors, had originally thought did the crime. You have to get this mountain of new evidence to prove innocence, and that takes so much time and so many resources, and that's part of the reason why we need all of these projects doing all of this work in very state-specific work.
kind of going back to the question I asked earlier about sort of the pre-existing conditions for why this happens. I guess I'm wondering if part of it has to do with what the public might see as is imperfect victims, or the way the criminal legal system might use a prior conviction of something completely different to be sort of the cover for saying, oh, well, don't worry about the details of this. This person already did this other bad thing years ago. And so, generally speaking, it's okay to just go ahead and convict them. So I'm just wondering how that plays into these decisions as well.
Yeah, I think there's no question that happens. I mean, we would have some cases where there's even trial testimony. Well, someone will say, well, of course they did it. Just look at them. But the very first thing they're doing is like, well, they were convicted of this, or they were suspected of this, or someone accused them of this earlier. Therefore, that is absolutely a risk factor for wrongful conviction. And anyone who has any kind of a record at all, there just seems to be this interesting leap, this cognitive leap that comes from if someone had, we have a system of presumption of innocence, but it doesn't even take a conviction in order for that to count against you when it comes to the investigation of the next thing coming down the road. And so absolutely, I would say that's a risk factor. It's also wildly inappropriate for prosecutors or law enforcement to suspect someone because, or for prosecutors to prosecute because, well, if they didn't do this, they must have done something. That's wildly inappropriate. It's anti-American. It's completely unconstitutional. And yet it's also hard to imagine with human beings being as faulty as we are that those kinds of cut corners don't happen. And cut corners are, I will just say, I mean, that those sorts of like technicalities, this drives me crazy to refer to a conviction being overturned based on a technicality. That technicality is the Constitution of the United States of America. This is important. There are reasons that those rules are in place. And so I would just caution anyone who kind of thinks that if we're more careful with actually innocent people, then a whole lot of guilty people are going to go free. That used to be the principle that we lived by under our law, that it was better for, 10 guilty people to go free, or 100, or whatever Blackstone's ratio actually is. But we've seemed to have gotten really far away from that.
I think there's no question that exists. We see that with juror interviews. After cases, they might say, yeah, they didn't have that much proof, but we just knew there was something more. This person wouldn't be on trial. The prosecutors wouldn't prosecute him if he didn't do it. So there must have been rules of evidence or some reason why there wasn't more evidence against them. We see it on the internet when we post stories of exonerees walking out. Most of the comments are very supportive and positive, but we will get comments without a doubt, like, he must have done something else. He looks guilty. I mean, on, internet stories where we've clearly proven innocence in a court of law. And even with the story I just told about Eugene, I've talked in many different groups and told that story. And I've gotten the question, why was his mugshot in the array in the first place? I don't even remember. It was probably some minor drug offense. It wasn't a violent offense, but it doesn't matter. He didn't do this, but it's already like, oh, well, he did something. He had a record. That's why he got wrongfully convicted. Yeah, that's why anyone's in any photo array, in any mugshot. You can get arrested, because you had like a little bit of drugs on you, or you did an OUI or whatever it is. But that judgment, that bias is very pervasive in our society.
And I think, Charlotte, you just said something that just makes me, I think that if someone is in if there's a photo array, then most people who are going to sit down, if you're a victim of a crime and you're given a photo array, there's an inherent, this implicit assumption that you don't even know you're making, that the bad guy must be there. That there's this it's not your instinct to say the correct answer may be no one is no one. Like maybe that person isn't here. And yet the way that eyewitness identification procedures are administered, law enforcement has a suspect in that array. And so they're going to be giving a whole lot of telegraphing that, we're only here, they called you in at 7 p.m. on a Saturday. They're going to believe that you must have someone there, right? And so I just have to highlight that, because I think that was a really good point. This belief that if they're here at all, if the question is being raised, then they're not like me, because I've never been arrested. I've never been in a photo array, and I know I'm a good person. So if they're here, they must have. It's natural, but it's also wrong.
Mm-hmm. just thank you to everyone who's putting in questions in the Q&A file. Appreciate that. Wondering if you have this information or not, but is there any data on kind of the number of people that are trying to have their cases reviewed? Or I guess maybe a different way of saying it is, what's the sort of backlog in terms of the number of cases that, you know, folks are asking to be, that are serious and are asking to be looked at versus the amount of resources and staff that you have to actually look at them?
Do you have those numbers for
You
yours?
you
It's
should
different
answer
project.
because my intake is very different. So because I teach a clinic with students, we have to do very limited intake. If certain cases that they can handle and the caseload is different, our pace is different. The bigger Innocence projects, and Laura can speak to this, like when I was at the Pennsylvania Innocence Project, we were getting hundreds of letters a year and we had a huge backlog. So I'll let you take this one.
Yeah, and I would say we're at the point now where we now are about to be fully staffed with 3 full-time litigators, which is the most that we've ever had as an organization, to have 3 people just working on that. And so we're hoping to kind of chip away at ours a little bit more. We probably have, 25 people that we have legal services agreements that we're in some advanced stage of work on their case, where we've actually gotten to the point where we're saying, you are our client, we are your lawyers, and we're going to be ready to file something in court, basically. But 9/10 of the work on a case happens in investigation, to try to kind of get in there and see what information you can get. Is there newly discovered evidence? Is this person actually innocent? Do they, where sometimes we discover all kinds of things, and we don't know if that person is guilty or innocent, but what we do know is that the evidence that's available is not going to be enough for us to be able to get back into court. So I would say hundreds is safe to say that are in some stage of trying to figure out, are there documents? Have we even gotten to this case yet? The different projects report on this. We do an annual report every year to the Innocence Network, because as a network, we like to know this. And in total, no doubt it's thousands. No doubt. There's probably tens of thousands, honestly, across the country.
And those are some that have been sort of vetted in some way, or
some have not. It just depends on the size and the capacity of each individual organization. Yeah.
And I think it's important to note that there are also thousands of innocent people who projects have taken on, and we've either been unable to prove sufficiently the innocence, even though we strongly believe that the person is wrongfully convicted, or we've tried and lost. And I think it's just important to remember those people, because there are thousands of innocent people incarcerated right now who no Innocent Project will be able to help.
I really appreciate that, Charlotte. I think it's sort of the part of the work that I think is most daunting for us as lawyers in that group. And, those of us who are working on those cases, it's extremely difficult to, we don't even take a case. We don't even pick up a case to look at it until all the appeals are exhausted. They no longer have the right to counsel. They're done. There are no further options in the formal criminal justice system. The state Supreme Court has to have said that they are upholding the conviction, or they decline to review it, and they are done. And so that's the stage where we enter in. And it is, I don't know what the standard is where you are, Charlotte, but in Washington, we have to have some sort of newly discovered evidence that was not available at the time that the trial happened. So it couldn't have been available and not presented unless it's DNA or something like that. But it can't be something that there was a strategic decision not to present it. So even if it was exonerating, there are circumstances where we aren't able to move forward with a case. So DNA is a little different. If DNA testing has not happened and it can be done, then that is allowed to be newly discovered evidence. But it can be extremely difficult to move forward. And I would say there are far more people who have requested assistance that are innocent, that we just haven't been able to move that case forward, or we've lost, as opposed to people who write to us who aren't actually innocent, if that makes sense.
I was wondering, getting back to sort of the root cause problem, what are some of the checks and balances? I guess this would be more for you, Laura. What are some of the checks and balances that we would need to have in Washington to kind of avoid having wrongful convictions in the first place?
Oh, so many. I think that first and foremost, it's really important to understand that all criminal prosecutions are brought forward at the discretion of the prosecuting attorney in every county. There is an evaluation if on whether or not you can get a conviction in a case, right? That becomes the question for the prosecutor. Are we going to bring this to trial? We even hear it sometimes in the news when you hear, if there's police misconduct cases where you'll hear the prosecutor get up in a press conference and say, we just don't think we're going to be able to convict. Like, the evaluation is less about, do we know what happened here? Did we figure out the truth? Or is it this more of an evaluation? Well, this is a bad guy. I've seen this guy before. And let me see if I've got what it can take to make it stick. Like, are we going to be able to get a conviction this time? And so I think that one thing that would be really, really, really helpful that does not exist anywhere. So this is pie in the sky, but having prosecution decisions to prosecute be evaluated by someone objective that is truly not interested, not even in the office. Have some sort of tiered process where you can say, who's going to prosecute? Are we going to prosecute this? Why do we think it's here? What are, vet that a little bit more instead of just saying, can we get this? The evidence that's used in prosecutions is still, there are still confessions that someone recants almost immediately. If law enforcement lied to them during an interrogation, like our client Ted Bradford, who's an exoneree from Yakima, he was told during an interrogation, 9 hours of interrogation, that they had DNA at the crime scene and his goose was cooked. So they better just tell him what they wanted to hear. In his brain, he's thinking, they have DNA, they're going to test it and realize they've made a terrible mistake. I'm going to say what I have to say to get out of this room, and it's all going to work out. It's all going to work out. And they didn't have any evidence that could be tested for DNA at the time. It took him serving his whole sentence before he was actually exonerated by DNA. But at the time, there wasn't anything like that because they can lie to you during an interrogation. And so you're in this situation where, why should it be allowed that someone makes a confession, immediately recants it, and that still be able to be presented in trial as, well, this person confessed, they confessed. It's sort of like this, no take backs from kindergarten, where you say that you're going to do something, there's no take backs. And that's crazy for a system that's supposed to be seeking the truth and finding justice. That's insane. And yet we've gotten so far away from that. If the process is just, see how many convictions you can get. Prosecutors are not rewarded internally based on how much justice they mete out. They are rewarded based on their conviction rate. There are very institutional factors that lead to that sort of attitude and reinforce it that really needs to be revisited. And I think just this broad discretion without anyone checking to see if it passes the smell test, everything is allowed to move forward, that we really need to re-examine that. How much true discretion really should there be? Mm-hmm.
Along those lines, one really easy policy fix is called open file discovery. So almost half of wrongful convictions involve some kind of government misconduct. The most common type of government misconduct is the prosecutor withholding exculpatory evidence from the defense pre-trial, which is a constitutional violation, but it happens all the time. And to Laura's point, that's because what is exculpatory is completely within the discretion of that particular prosecutor. So there's issues with new prosecutors or they weren't well trained. It's not necessarily malicious. But if the prosecution just let the defense see the whole file, and we just had open file discovery, which some prosecutors' offices nationwide are adopting post-conviction. I don't know if anyone's doing it pre-trial, but there are some conviction integrity units doing that post-conviction. Then the playing field is a lot more level. It won't solve every problem, but at least we'll go into it without having exculpatory evidence hidden from the defense.
Great, thank you. Before we move to the audience Q&A, and we have some great questions that have already come in, is there anything else that you want to add? I know we didn't get all the questions that I had, but is there anything else you wanted to add before we move to the audience Q&A?
I think I would just emphasize, I mean, one of the things that you had asked earlier is, what is it that why isn't there sort of more support for this kind of work? And I think that one of the things that's so daunting about this work is that it is a long game. It takes, as Charlotte pointed out, it takes many, many years to litigate these cases, even in the best scenario, a 5-year exoneration would be warp speed. I don't know what it's like for Charlotte, but like that would be a warp speed. And so that's a really long time. And then once everyone is out, that journey is just beginning. I mean, the trauma that's affiliated with that, and that just requires more and more resources. The more successful we are in terms of getting people out of prison, the larger our freed and exonerated community, and the needs of that community are extensive. They're wide and they're deep. And so, I do think that understanding that in terms of general philanthropy, we get our support through people who donate, understanding that we're not going to have an exoneration every 6 months. We're not going to have these big, big, shiny, beautiful stories, but that this is fundamentally critical work for our justice systems to even, begin to start to understand how to correct, to become better. This work is just really important in that way. And I think has the opportunity to be really powerful. So to just support the local Innocence Network member organizations that you want to, do not write a check to the Innocence Project in New York. It will not come to us. Please, go to the individual Innocence Network member organizations and do what you can to support them.
Thank you. All right, we're going to move to audience questions. Thank you again for submitting. These are great. The first one I want to ask is, how much harder is it to free an innocent person when you don't know who really committed the crime?
The short answer is it's a lot harder, but that's most of our cases. So we usually can't determine who the real perpetrator is. We just know that there is new evidence that's not consistent with our client's guilt. In DNA cases, there's a lot of DNA cases where they have been able to identify the true perpetrator after the exoneration, because of course they have the DNA that doesn't match the exoneree. And there's lots of new technology and ways that the science is being used to identify the real perpetrator. But in your typical non-DNA case, we are not able to identify the real perpetrator. In the cases where we have, that person is very rarely charged with the crime. The prosecutors typically tend to continue to insist, even post-exoneration, that that their original conviction was correct. And so the true perpetrators are rarely charged or convicted of crimes, even when identified.
Yeah, I absolutely echo that. But to kind of flip your question on its head, Naomi, I think it's actually the audience question, it's extremely difficult for us to exonerate an innocent person, whether we identify the actual perpetrator or not. It's exceptionally easy for a prosecutor to exonerate an innocent person. And I think that this is where the discretion doesn't get less after conviction for prosecutors. If they are presented, there's an ethical rule, RPC 3.8, where prosecutors have an ethical obligation when they learn of evidence of innocent, that someone who is wrongly convicted in their jurisdiction, that they proactively do something about that. And I've never in Washington state had a prosecutor come to me with a case that they thought there was some question about the conviction, and more often we are fighting them. So also in our cases, there's been one of our exoneration cases, a DNA exoneration case, where our client was wrongly convicted at the age of 18 for murdering his mother. He spent 16 years in prison. The DNA identified someone else. They prosecuted him. And he was acquitted. But other than that, we have other cases where the DNA pointed to that person and they have not prosecuted and never explained why they weren't prosecuting. And the case that I mentioned earlier of our client, Cody Klepper, was a Benton County case where the single perpetrator sexual assault, and there is what's called a CODIS hit. So the DNA, the FBI's database of DNA, the crime scene evidence hit on someone else. And they have not only not prosecuted him, they're continuing to stick with the story that our client was at. So I don't know that... I think that with the right prosecutor, with a just prosecutor bringing forward that sort of evidence, hopefully that would make it a lot easier. But I agree with Charlotte. It's a rare case where we actually have enough information to actually know who the actual perpetrator may have been.
Yeah, I guess a follow-up question I had to that is, what would be sort of the lever that would? It sounds like there's a practice that's become normalized and nobody seems to be pushing back against it. I mean, who would be sort of the entity that would hold those prosecutors accountable?
I suppose voters. I'm not sure how it is in Massachusetts, but all the county prosecutors are elected officials. And so, pressure from from the constituents, I would imagine. I think there's probably some countervailing forces bearing on the prosecutors when there is an exoneration case where they can point to official misconduct, which, as Charlotte mentioned, more than 50, the leading cause of wrongful conviction nationally is official misconduct. That's just a fact. 57% of all exoneration cases, DNA or non-DNA, involved official misconduct. And so there is some concern probably on the part of county auditors, people who hold state budgets and county budgets that are going to be hit with big lawsuits, that you know, the marching orders are fight, 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 and don't admit fault. So you know, I don't know if the community doesn't get up in arms. You know, I think it was Scalia, and I could be wrong, in a wrongful conviction case that had gone to the Supreme Court, he, in his opinion, said if there was an innocent person that was, you know, put on death row or executed, people would be marching in the streets. And here we are with 3,399 known cases of wrongful conviction just since 1989, and people are not marching in the streets. And so we're trying to kind of find that, where are those levers? I don't know, other than litigation, and litigation takes years and years and years. We have a lot of prosecutors who will say that they will do all the right things before they're presented with an actual case. And that's really difficult. You know, we have very progressive prosecutors in Washington, this and that, but when they're faced with a real case, they fight it just the same as their neighbors in other counties. And so it really hasn't borne out that we have that model prosecutor's office, at least in Washington state, where you know, where we have someone really making a proactive effort to make sure that the convictions from their jurisdiction are safe. We don't have anything like that here.
There are a few nationwide there. So there was a movement about a decade ago that caught some traction with prosecutors starting what they call conviction integrity units in their offices, where they are really tasked with ensuring that justice was done in their convictions. And there are a few offices nationwide where the prosecutors have actually been very proactive and on their own exonerated dozens of people with their own motions and doing their own investigation. But they're very, very rare. And there are many conviction integrity units that don't actually, we call them in name only. They have the name, but they're not actually doing the work. So the model exists, but there are even the offices that have started the units aren't necessarily following those models.
Mm-hmm. All right. So the next audience question is, and you touched on this a little already, but it's been a popular trend to prosecute minors as adults. How has that affected the convictions of innocent people?
Well, I have to take this moment to talk about our most recent exoneration from August. So 2 months ago to the day today, 2 months ago, our client Evaristo Jr. Salas was exonerated from the bench in a surprise exoneration. It was very Hollywood moment. We're in the middle of what's called a reference hearing. We were developing evidence that we believed would establish his innocence at the trial level. And in the middle of that testimony, it became clear that the law enforcement officer had framed him, and we were able to get that out on the record. And so they dismissed his case with prejudice from the bench, meaning there was no possibility he was going to be retried, and he was exonerated. But Junior was 14 at the time that this murder happened, and he was tried as an adult at 15. So he went to Walla Walla at 15 years old and 105 pounds and grew up there. And he was just released 2 months ago at the age of 42. And so this is you know, we don't have any shortage of cases where our clients were very young. And that in his case, you know, he was framed by law enforcement, essentially, and an informant who was drug addicted and gave testimony because he was told to, and an eyewitness who knows, possibly was hypnotized, according to the evidence that we were able to develop. And so there really was no way around that. But many of our clients, just to move away from this just a little bit, because so many of our clients are right around the age of 18, 19, 20, that they aren't juveniles, but they're very, very close in that. And just what we know about brain development these days, and as Charlotte was talking about earlier, the sort of propensity to falsely confess, or the risk factors to falsely confessing and being pressured through that system, are even more so for those who are very young.
Charlotte, did you want to add to that at all?
think that was well said. I mean, the only thing I'll add, I had a recent exoneration. My client was 17 and convicted of murder for an arson that was actually an accidental fire. Arson science has changed significantly over the last few decades. There have been numerous exonerations based on science showing that indicators that we thought proved arson or incendiary fires actually could exist with accidental fires. So he was only 17 years old and at a party where this fire occurred. And I think one of the biggest things with the juveniles being charged as adults, of course, it's, the sentences that they're given and the lack of programming. And he came up for parole 4 times in the 35 years he was incarcerated since the age of 17. And every single time he had to waive parole because he wouldn't accept responsibility for something he didn't do. And there's a huge problem with our parole statutes. They require for you to take responsibility. And so innocent people end up serving significantly longer sentences than guilty people because they just can't say that they did something that they didn't do. And so from that very, very young age, he ended up serving far more time than he would have if he was prosecuted as a juvenile.
And sorry, Laura, what county was that most recent case from?
Yakima.
Okay. And just hopefully this will be an easy one. A question from an audience member. And this was way back in 30 minutes ago. What were you referring to in terms of, quote, objective limits or review of prosecutions?
Was that for me? That question for me? Oh, I think, I don't know about objective. I don't know if I'm sure I said that, and I think it was not very well said. I think that having some sort of less biased, less invested perspective on or review before prosecutions move forward, or when a case is brought forward, even if it has gone to trial, maybe if it's something sort of like a conviction review unit, if there's reason to question that, to not have the review happen by those who are already so invested in the outcome, to have it be a little bit less passionate. There's a reason that we don't have family members on juries, and maybe there's a level of sort of emotional connection and commitment to convictions and to prosecutions that are happening that are influencing people. I was really surprised to learn pretty recently that in King County, homicide prosecutors go to homicide scenes, and I think that this is so alarming, and I don't understand what the value of that is, that it's not the prosecutor's job to prosecute or to investigate. It's their job to prosecute what has been investigated. It's law enforcement's job. So other than kind of getting them emotionally attached and sort of less objective, I'm not really sure what that is supposed to accomplish. And so they can't be witnesses at the trial, right? So they can't say, I saw this at the crime scene. Like this, it's such a quandary to me. And so I think that getting emotion out as far out of the prosecution process as possible, and like get back to just the facts. Is this a case where there's enough that there is evidence that this person did it, and does it pass the smell test? Not do you think that this is a bad person, but the American criminal Constitution says that we look at what are the facts in this case. Is there evidence that this person committed this crime? And I think we've, because of the level of discretion that's available to prosecutors in terms of prosecuting, what to charge, who to charge, how many charges to charge, what level, whether it's a misdemeanor or felony, all of those things, that level of discretion is, I think that reasonable minds would differ about what the proper and just path forward is if you take emotion out of it. So I'd love to see a little bit more of that.
Naomi, I think you're muted.
Unmute, Naomi.
I'm sorry. Thank you. Sorry, this is a good segue to a question that was just asked, which is, why do prosecutors and police have such broad discretion if we believe people are innocent until proven guilty?
That's a great question.
Charlotte, do you want to add?
That's a great question. No, but I
think it should be that way. So we're like, why?
Yeah. An excellent question. I mean, I think it's just a throwback. I think we all there was a time before the innocence movement, really, where we could all say, I am confident in what I just saw. Like, of course I could say, identify a person if a crime was committed. You just have a level of confidence about that doesn't correlate with accuracy. Just because we're confident doesn't mean we're right. And I think that it's the same. We know that now from scientific study, but I think that there was just a lot of trust in the system that it's a civic duty that you're representing the state. And I think there is a lot of that. I think there are a lot of prosecutors and law enforcement officers who really do go to that with that belief. The problem is that just because you're in that role, it doesn't give you a superhuman ability to know when people are lying or to be able to decipher what really happened in any given situation. None of us were there. And so I think that the concept that any one player in that process could have some sort of talent or ability to see more and know more and sort of have a moral authority is just wrong. And yet we've been proceeding that way in this country for a really long time. How many times have you heard of a good old-fashioned police work? Well, also, how much of that good old-fashioned police work is just your gut? And that is very, very dangerous. You cannot, we can't continue to tolerate that standard in law enforcement and prosecutions. It has to be more than how you feel about it. It has to be what you see and what you observe and what you know.
So a Washington specific question. We think of our Washington AG as a good guy. How come his law firm always works against compensation for exonerees?
Oh, such a good question. I think that I will characterize our AG as very litigious. I think that's fair to say. Like using the system, using the litigation system to enforce people's rights, to go against then President Donald Trump. It's a very litigious office. It was a new statute in 2013, and that was the first year that Bob Ferguson was in that office. As a new statute, you're compensated if you're able to show by documentary evidence that you did not engage in the conduct that was charged in the underlying documents. This was all new. The compensation law is really the only legal device in Washington state that says you are an actually innocent person. Even if you're exonerated, that just means your conviction's overturned and you're not re-prosecuted or whatever. But there's no declaration anywhere else except in the compensation statute to say that someone is actually innocent. And I cannot speak to why they make the choices that they do. I think many have been really, really questionable. But there are a lot of people, my understanding is a lot of the people who are taking the lead on those cases, former Department of Corrections employees, they're former prosecutors. We all come to our work, whatever it may be, with the history that we have behind us. And again, being biased doesn't make you a bad person. It just makes you a person. And so having been the person who, wrote with my students the statute and then watch how it's been applied, it's been incredibly disappointing. And I think that's because it has created so much more pain and process and lack of justice for those who have been wrongly convicted in the state. And that has been because they've been required to answer to, frankly, the biased judgment, of those in the AG's office who are choosing to represent these cases. And there's one case in particular where the trial court, there was a recantation in a case and the criminal conviction was overturned. He's seeking compensation. And the AG's office said explicitly, we don't believe the victim in this case who recanted. It's not, by my estimate, that's not the AG's office role to do an evaluation of whether or not the criminal court should have believed the recantation. They did. And that court found that he was not guilty of the conduct in the charging documents. That is how we wrote it. It was intended for that to compensate those people. We are still 10 years down the road in the process of that law being interpreted. And we're going to need to go make some fixes to it to remove some of that ability to challenge these cases, so that in cases like, for example, a DNA exoneration case, that maybe flip the presumption so that the Attorney General's office has to show us why they're fighting this case, as opposed to making that wrongly convicted person have to fight even more if the criminal case has already given them relief.
Great. And then the very last question, then we're going to wrap up. I know this is a big question, so hopefully we can do it quickly. What are the typical steps you take in attempting to overturn a wrongful conviction?
Sure, I can take this. I'll speed answer it. So there is sort of a typical case, typical path of a case. So we get a letter from an inmate requesting our assistance, saying that he or she has been wrongfully convicted. We do an initial screening just to determine if it meets our basic criteria. If it does, we gather as many documents from the case as we can. That's often a very, very challenging part, especially for older cases. Nothing is electronic. Everything is hard copies of transcripts that are really difficult to get and or very expensive. So it can often take months just to gather the documents. Then we review all those documents. We write a very lengthy report. We do another screening process to see if it's a case that's a plausible case of innocence and one where we think that there's a viable path to success in the courts. If yes, then that goes into an active investigation where we're knocking on doors or consulting with experts or doing whatever we need to do to try to uncover the new evidence that could prove innocence. Many cases end there because we can't find it. But if we are successful in uncovering new evidence in that investigation phase, again, that's lengthy, that's a number of years, then we file in court a new trial motion. Laura probably calls it something else, but it's probably basically the same kind of motion saying this is our new evidence, or this is our constitutional violation, or this is what we've uncovered, why this is a wrongful conviction. And then it goes through the court system, which typically involves an evidentiary hearing, which would look exactly to the layperson like a trial. You're putting on witnesses, direct and cross-examination. You need to prove to the judge that this new evidence is credible. And then a judge makes a decision about whether or not the convictions are vacated. That authority, at least in Massachusetts, comes down to one person. One judge makes that decision. Of course, you can appeal it. Either side can appeal it. So often there's a lengthy appellate process. Then it goes, if you're successful in vacating the conviction, it goes back to the prosecutor who gets the final decision on dismiss or retry the case. That was my speed answer.
7 years of work in 30 seconds. Well done. Well, that's it for our questions. And thank you again to the audience for these great questions, and for both of you for doing such a great job of sharing this all with us. Thank you.
Thank you so much.
Yes, and on behalf of MOHI, the Alliance and Grandmothers, a huge salute and thanks to you three. This was really informative, and a couple things really impressed me. Laura, you drew some parallels between those of us working on gun violence prevention and the work you all are doing. You know, we are engaged in the slow march to social change and building up public support for this and educating the public about what this is all about. And I have a lot of respect for the three of you, and Laura and Charlotte, your work, and Naomi, you're giving your time to help us. And maybe this evening could be understood a little bit as helping to develop the levers of change, making more people aware of the Innocence Project. And I'm really so struck by the conviction versus justice dynamic, and not unlike what's in gun violence prevention, the my gun rights, and you know, how do we resolve these as societies? And it does my final comment would be, Charlotte, on your wonderful new work about help with reentry. Kudos to paying attention, to that, and to mental health. I don't know if people who have been exonerated have been required to forfeit gun ownership rights. I have no idea, but it does occur to me to put a little plug in here that it's a good time to educate people about gun safety as people are reentering. So on that self-serving note for our work, thank you all so much. And thank you everybody for being here tonight, and take care.
Thank you.
Okay.
Thanks,
Bye-bye.
Naomi.